Hi, everyone. I'm going to go ahead and get started with our introductions. I know some folks will still be joining us over the next few minutes, and that's totally fine, but I don't want to waste anyone's time, and we've got a lot to cover. So we'll go ahead and get started. First of all, I'd like to introduce the folks that are joining me today. My name is Trisha Teofilo Olave, and I supervise our VAWA and U-Visa Pro Bono project here at the National Immigrant Justice Center. I'm going to pass it over to my colleagues who can introduce themselves. Lisbeth?
Hi, everyone. My name is Liz. I work with Trisha. I'm the VAWA and U-Visa Pro Bono project coordinator.
And Ellen?
Hello, everybody. My name is Ellen Miller, and I have the honor of being the pro bono manager at NIJC and working across a variety of projects. So maybe you've gotten some emails from me, and I'm super excited that for such a great turnout today. And Trisha and Liz are experts at U-Visa, so I'm excited to hear what they have to say. Thanks.
Thank you very much. And just so that you all know, we are your team that you're communicating with for U-Visa cases, and in addition to Marissa Labella, who is also on our U-Visa Pro Bono project as a paralegal. And amongst the four of us, you can feel free to reach out to any of us with questions about U-Visas, or if you have questions about other types of pro bono cases here at NIJC, and we'll make sure you get in touch with the proper people. Okay, so I see that we've got a number of attendees on the webinar, so that's great. We'll go ahead and get started. Some of you I know joined us last month for our VAWA training. That's great. If you missed it, we're going to have another one next month, so feel free to reach out if you're interested in attending that. So we're going to go ahead and get started. Today, we are covering representing immigrant survivors of domestic violence and other qualifying crimes, the U non-immigrant visa. And today's presentation is intended to train pro bono attorneys, so volunteer attorneys who are assisting with NIJC U-Visa cases, okay? This training is not intended to provide legal advice for people who are not authorized to give legal advice, okay? So this training is specifically intended for attorneys and accredited representatives, and we do not want to encourage unauthorized practice of law. To begin with, I want to explain a little bit about NIJC for those of you who aren't familiar with our organization. We have a very unique approach to the work that we do in that we provide direct legal services to over 10,000 immigrants annually, but we also have our federal litigation project that does litigation at the federal level, and we have national and local advocacy at the state level, the local level, and the federal level. So we are able to work on both policy and advocacy and litigation and direct legal services, but we're also able to do this because of our strong pro bono network. Okay, we have more than 2,000 pro bono attorneys who assist us in filing many different types of applications, and we're honestly able to do the work that we do because of people like you. So thank you so much for being here. All of our clients are at or below 200% of the federal poverty guidelines, and so we can provide consultations for anyone, but if someone is over our income guidelines, we do refer them out. Today's agenda, we're going to talk very briefly about the various pro bono projects here. We're going to talk about U non-immigrant visas and how someone is legally eligible to apply for a U visa. Then Liz is going to take it over and talk to you about working with survivors of domestic violence. And although not all U visa applicants are survivors of domestic violence, many of our clients are, and these are really good skills to have as a pro bono attorney, specifically for VAWA and U-Visa cases, because working with survivors of domestic violence requires some additional skills that really are important in providing trauma-informed care, okay? And then we'll take a small break, and Liz will come back and talk to you about preparing a U-Visa case, the nuts and bolts of what goes into the application. And we're going to give you lots of references and referrals and contact information so that when you take on a pro bono case through NIJC, you will be 100% prepared to prepare the case. So at NIJC, we have a number of pro bono projects. We have an asylum project that represents clients who are fleeing persecution in their home country. Our Adult Detention Project represents people who are detained by ICE. Our litigation project files federal litigation claims. And we have clinics for DACA, Deferred Action for Childhood Arrivals, and naturalization. We also have a project that works with special immigrant juvenile status for children who have been abused, abandoned, or neglected. And then we have our VAWA and U-Visa Pro Bono project. The way our pro bono projects work is clients come to us through our consultation appointments, and we screen for eligibility. We do in-depth case screening for all of our clients and make sure that their cases are ready to go before we pass them on to a pro bono attorney. Okay. If we accept the case, then we will sign a retainer with the client and search for a pro bono attorney to represent them. But by the time we pass the case on to you, we have already done that in-depth screening. We've signed a retainer with the clients, and we've made sure that their case is ready to go. So once you accept the case, we do remain of counsel on these cases, and that allows us to continue to provide support, document review, and technical assistance throughout the life of the case. Because we remain of counsel, it is very important that you and us maintain contact throughout the entire life of the case. Okay, so in these cases, our responsibility is to provide training to all of you. We do outreach at various places in the community, domestic violence shelters, hospitals, schools, clinics. We also create that case referral packet for you and continue to provide support throughout the life of the case, which will include things like trainings, technical advice. We can give you sample filings. We'll update you on any new updates to the law and policy. We provide malpractice insurance, and as I mentioned, we remain of counsel. Your responsibility is, once you take on a case, we ask that you conduct a conflicts check, make sure that you have no conflicts with the client, and schedule a client meeting. We ask that you reach out to the client relatively soon after taking on a case to make sure that you establish that relationship and rapport with the client, and that you prepare and file the case within about 8 to 12 weeks, okay? You must represent the client for the duration of the case, or if something happens and you can't do that, we ask that you obtain substitute counsel within your firm, okay? You also need to provide translators for interpreting throughout any client interviews, translating any foreign documents. Oftentimes, this can be done with support staff at your firm, or if not, then you can seek out volunteer attorneys. Okay, we can provide some volunteer attorney lists if necessary. But we ask that you also keep us informed of any filings, any requests for evidence that you receive, any case decisions, and any questions or concerns that you have. With U-Visa cases, and we'll go over this more later, but all of the correspondence goes directly to you, the attorney of record. So the client isn't going to receive any notices, and neither are we. So it's very important that you are staying on top of all the correspondence for the case and making sure that both NIJC and the client are notified. The client obviously has responsibilities too, and they need to be truthful and open and honest in their communication with you and with us. We ask that they communicate with you and provide you with any updates on their contact information or changes in status if they were to get married or divorced or arrested, okay? We have a number of resources available to our pro bono attorneys that include samples, cover letters, briefs, forms, how to frequently asked questions, and all of the latest policy updates. You can find all of this on our website. It's www.immigrantjustice.org. Okay. So we are going to dive right into the training, but I should have mentioned earlier, feel free to submit any questions that you have in the chat, and we will do our best to answer them throughout the training. Also, you know, we'll try to provide time at the end of the training to answer any additional questions. So what is the U non-immigrant visa? Well, the U visa was created back in 2000, so it's over 20 years old now, and it was created to strengthen the ability of law enforcement agencies to investigate and prosecute cases of domestic violence, sexual assaults, trafficking, and other crimes while also offering the humanitarian protection to the victims of the crimes. Unfortunately, it took about 8 years for the regulations to be developed to tell us how people could file for U visas. And so for a few years, there weren't that many applicants because people didn't know or couldn't file for U visa status. But since then, the U visa has become more wide known and more well known, I should say, and more people are applying for U visas, which is great because a lot of people qualify for U visas. What that has led to, unfortunately, is a significant backlog in U visas, and we're going to talk more about that later, but that is one of the hurdles in applying for U visa status. It still is worthwhile, though, for people to apply for U visa status if they're eligible, because it provides them with a mechanism to remain in the United States lawfully, okay? The U visa is part of the Victims of Trafficking and Violence Prevention Act, and it does lead to a path to citizenship. Okay, although the U visa is a non-immigrant visa, once someone is granted a U visa, they are eventually eligible to apply for the green card and then hopefully citizenship. So here you'll see the various actors involved in a U visa application. It includes the client, you, the pro bono attorney, and us, NIJC, USCIS, that's the U.S. Citizenship and Immigration Services. That is the agency that adjudicates these applications, and it also includes the law enforcement agency. So the law enforcement agency could be the police department, or it could be a prosecutor. I am going to ask Liz to put up the first poll and ask all of you if any of you have prepared a U visa case before.
Just a few more seconds. Okay. So it looks like, since Trisha, you can't see the results, it looks like 21% of people said yes, they recently have. 10% said yes, but a long time ago, and about 59% said not yet, but they're interested. And then the rest, either they're not attorneys or DOJ representatives, or they don't think they'll be working on anything like this soon.
That is absolutely fine. That's very helpful. I'm hopeful that this training will be informative for all of you, regardless of your answer there. For those of you that have filed U visa cases in the past, that's great. You're obviously got some experience, and that will be helpful for any future cases that you take. But for those of you that have never done this, don't worry. That's exactly why we're here today. And for those of you that don't plan on filing U visa cases, that's fine too. Hopefully this information will help you understand the purpose of the U visa, who is eligible, and where you can refer them when you come across somebody who might be interested in applying for a U visa. Go ahead with the poll number 2 right away, Liz. So this poll is for folks who have previously filed a U visa application. We're really interested in learning what was the most difficult part of the process for you. We want to be able to target our technical support to you most effectively.
Okay, I'm about to close the poll. And so the results are that for those that have worked on a U visa case, the most difficult part, 25% of people said that working with the client. 38% obtaining the certification from law enforcement, 25% of people said preparing and filing the application. 38% for both waiting for adjudication and maintaining client contact throughout the life of the case.
That is really interesting to me and very helpful. It's actually like very widespread, right? What people are experiencing as different challenges. To me, it tells me that every part of this process can be challenging, which is okay. It's good to know that because we want to be able to be here to provide the support that you all need. I don't want that to discourage any of you who haven't taken a U visa case thus far. Hopefully this is encouraging because you will know that we are here to provide that support. As you've heard, there are various challenges, but there are many benefits to applying for a U visa. As I mentioned, it's a non-immigrant visa, and once someone's approved, they're given a visa for 4 years with possible extensions. After 3 years in U status, you can apply for a green card and eventually possibly apply for citizenship. And additionally, you can include derivative family members, okay? That relationship, as of right now, here in the 7th Circuit, must exist at the time that the I-918 is filed. There was a recent court decision in the 9th Circuit that actually allows for following to join in the U visa application process, but it's currently only in the 9th Circuit. So we're not going to talk about that much today, but if you are working in the 9th Circuit or have a case out of the 9th Circuit, then we would ask you to reach out to us separately. Limitations. So if I'm applying for a U visa based on being a victim of a crime, I cannot apply for derivative status for the perpetrator of that crime, okay? So for example, if my friend or family, well, I guess friend doesn't matter, but if my family member committed domestic violence against me and I'm eligible for a U visa based on that crime, I can't then include that person as a derivative on my application because they are the perpetrator of the crime. And then the biggest limitation for most of our clients is this annual cap of 10,000 U visas per fiscal year. Okay, so as I mentioned earlier, there's a huge backlog right now in U visa adjudications, and USCIS is currently adjudicating cases that were filed in 2015 and 2016. So that is for most of our clients the biggest limitation, but there's hope that with this new administration and some progressive voices in Congress that maybe that cap will be raised. Who knows? For now, it continues to be 10,000 per fiscal year. Okay, so if I'm applying for a U visa, who can I include as my derivatives? Well, it really depends on the age of the principal applicant, okay? So if the principal applicant is under 21 years old, then they can include their parents, they can include siblings who are under age 18, they can include any children who are unmarried and under 21, and they can include their spouse. So hypothetically, if you think about this, you've got a 20-year-old victim of a crime, they can include their 2 parents, they can include a spouse, they can include any unmarried children under 21, and they can include any siblings under age 18. So that could be quite a few people, and that could be very life-changing for that family. Only the principal applicant counts against that cap of 10,000 U visas per fiscal year. So include any and all derivatives that you've got. If the principal applicant is over 21, then the derivatives that they can include are their spouse and any unmarried children who are under 21 at the time of filing. Okay, the age is locked in at the time of filing, which is very important, right? Because if these cases are taking years to be adjudicated, obviously kids can turn 21. That's okay. They won't be bumped out of eligibility as long as the application was filed when they were unmarried and under 21. They do need to remain unmarried. If they get married during the the time that the case is pending, then they will fall out of eligibility. Now here, we offer the standard of proof for these cases is any credible evidence, and that can be found in the Code of Federal Regulations at section 214.14 C4. This is important because sometimes we have to remind USCIS that the standard is any credible evidence. And Liz is going to talk to you more about the challenges that survivors of domestic violence have in gathering documentation. But sometimes there's little to no evidence to be obtained. And if you're fleeing an abusive situation, you may not have had the opportunity to gather that evidence. And so we have to oftentimes remind USCIS that the standard is any credible evidence. Now, who qualifies as a victim? Well, most obviously are direct victims, the person who is directly and proximately harmed by the qualifying criminal activity, okay? And we're gonna get into what qualifies as criminal activity shortly. This can include bystanders, okay? So that would be someone who witnesses a violent crime and suffers an unusual direct injury, but those are pretty rare cases. The most common example of a bystander case is a pregnant woman who happens to miscarry as a result of witnessing a violent crime, okay? So that, again, is relatively rare. Indirect victims, on the other hand, is relatively common. If the primary victim, the direct victim, is murdered or incompetent or incapacitated, then the direct victim can include their spouse, children who are under 21 years of age, parents, if that direct victim is under 21, and siblings, if the direct victim is under 21. So in this context, the most common scenario that we see are child victims of sexual assault, and their age at the time of the crime is what counts here. And so if the child was a child at the time that the crime was committed, then they would be considered the direct victim. But because they are considered incompetent or incapacitated due to their age, the parents qualify as indirect victims, okay? So that third bullet there, if the direct victim is under 21, then the parents can qualify as indirect victims. And that's the most common scenario we see of indirect victims. Obviously, there are others. You know, if the direct victim was murdered, then the spouse or children or parents could potentially qualify as indirect victims. So in order to qualify for a U visa, what do you have to prove? It's not just as simple as saying, I've been a victim of a crime. You have to prove that you've been a victim of a qualifying crime and that you've suffered substantial physical or mental abuse as a result of that crime. You have to show that you have been helpful, are being helpful, or are likely to be helpful in federal, state, or local investigation or prosecution of the crime. You have to show that you possess information concerning the criminal activity and that that criminal activity violated US law or occurred here in the US. Here's a list of the qualifying criminal activity, okay? We're not gonna go through all of them, but these are the crimes that are listed in the statute, but the statute also says the crime can involve one or more of the following or any similar activity in violation of US law, right? So this list is not, it's not limited to this list because many laws vary from state to state and from jurisdiction to jurisdiction. So for example, if we don't have an extortion law on the books here in Illinois that qualifies the person for criminal activity under the U visa statute, but what they've been a victim of is a similar activity, then they could still potentially apply for a U visa if the crime that they were a victim of is similar to a federal, state, or local statute. Okay, and it also includes any attempts or conspiracy or solicitation to commit any of these crimes. So an attempted murder, okay, or an attempted kidnapping could qualify somebody for a U visa, even if it didn't actually happen. Okay, so going on to each of these elements, the substantial physical or mental abuse, how do we prove that? Well, let's first look at that definition of abuse. So according to the Code of Federal Regulations, it's injury or harm to the victim's physical person or harm or impairment of the emotional and psychological soundness of the victim. Okay, so USCIS here can consider a series of acts. It's not limited to any single factor. And that's important because as Liz is going to talk about, in the domestic violence context, oftentimes it's a cycle of abuse, okay? It's not limited to one specific incident. And oftentimes the incident where the client reports to law enforcement might not be the most severe incident, okay? What you're going to learn with regards to domestic violence is a lot of times people are fearful to report the abuse for fear of retaliation, for fear of further abuse, okay, because of threats that they've received. So maybe this abuse has been building and building and building, and there have been multiple incidents that were never reported. And maybe finally something gets reported because the neighbors called the police or something like that, right? And then that specific incident maybe didn't seem as severe, but when the person is applying for the U visa, you can include everything that they've been a victim of, and USCIS can consider the series of incidents surrounding that domestic violence, okay? They'll also look at the nature of the injury inflicted or suffered by the victim, the severity of the perpetrator's conduct, severity of harm suffered, and the duration of the infliction of the harm. So that's where we're talking about years of abuse, okay? That doesn't mean that somebody who has been the victim of one incident only can't get a U visa. That's not what I'm saying. I'm just saying that if you have a client who has experienced years of harm, you can make that known because that can make your case stronger. You have to prove cooperation with law enforcement. Now, this is especially important. You'll see in that yellow box there, you have to have the law enforcement certification. It's Form I-918 Supplement B, signed by law enforcement, okay? So as we asked in the poll, for some people, obtaining this certification was the most difficult part. With our pro bono cases, we try to make sure that the client has a signed certification before we pass the case on to you, okay? So hopefully you won't have to obtain a signed certification. I will say that in some instances, the certification expires and then the client, with the assistance of their pro bono attorney, has to obtain a new certification from law enforcement, okay? So fortunately, here in Illinois, we have the Voices Act, which requires law enforcement to sign a certification if someone has been the victim of a qualifying crime. But so usually obtaining the certification here in Illinois is not the most challenging part. However, sometimes people do run into roadblocks when it comes to obtaining the certification. And so we really encourage clients who have a signed certification, if it is a valid certification and it's a good certification, we encourage them to apply for the U visa before that certification expires in 6 months. Okay, so the law enforcement certification is only valid for 6 months. I'm going to get to that on the next slide. Before I go there, though, this cooperation with law enforcement component, you have to prove that you have assisted in either the investigation or the prosecution. It doesn't have to be both, okay? And that's really important for you to know because you might have a client who only assisted in the investigation and there was no prosecution. That is totally fine. You might have a case where somebody assisted in the prosecution, but they didn't actually report the crime, and that's okay. There is an ongoing responsibility on the part of the victim to continue to be helpful. So for some of our clients, these crimes occurred years ago and there is no necessary ongoing investigation or prosecution, so there's no need for them to continue to cooperate. But for those clients who have been victims of crime recently, if the case was recent or is still ongoing, then there is a responsibility that they continue to cooperate. The possession of information is also a requirement. The individual must have knowledge of the details of the qualifying criminal activity so that they can assist in that investigation or prosecution. So here's that certification. The form, it's a USCIS form. It's Form I-918 Supplement B, and it must be completed and signed by the head of the certifying agency or someone who is designated by the head of the agency to sign certifications, okay? Or it can be signed by a judge. So we've filed cases with certifications signed by a local police department or by a state attorney's office, by the FBI, by a judge. All of those are valid certifications. The important thing is the certification must have been signed within the 6 months immediately preceding the submission of the petition. So USCIS is very strict on the 6 months. If the certification is signed today, February 25th, then it has to be filed. The U visa application must be filed and received at USCIS by August 24th. Okay, if you wait until August 25th, that is 6 months and it is considered expired, the certification. So it has to be within the 6 months preceding the submission of the U-Visa application. The certification form is not conclusive evidence of any of the eligibility requirements, but it is a requirement. If you don't have a signed I-918B, you cannot apply for a U-Visa, okay? And you must submit the original. So this is important. As a pro bono attorney, we strongly encourage you to obtain that original certification in your first client meeting. Okay, now during the pandemic, most people are not meeting with their clients in person, and that's fine. You don't have to. You can do everything remotely, but you will have to obtain some documents from the client, and you're going to have to obtain client signatures on forms. You absolutely need this original U-Visa certification. If you don't have the original, you can't file this U-Visa application. And keep in mind that a lot of our clients don't speak English, and some of our clients are illiterate. And so we do explain to them the importance of this certification form, and we advise them to keep it in a safe place. But for somebody that doesn't speak English or is illiterate, most of the documents that they have look the same. And so I just encourage you to try to get your hands on that certification sooner rather than later, because we have unfortunately had people scrambling at the last minute to try to find the original U-Visa certification in order to meet the filing deadline. Okay, now all U-Visa applicants must prove that they are admissible. Okay, so inadmissibility is a common term used in immigration law. Anybody who is applying for an immigrant visa or non-immigrant visa needs to show that they are admissible. Okay, fortunately, the U-Visa offers a waiver of inadmissibility, and the U-Visa waiver is one of the most generous waivers available to anyone. Okay, so if you have a client who has various grounds of inadmissibility that apply to them, they can apply for a waiver on Form I-192, and all they have to do is show that it is in the national and public interest for their waiver to be granted. So what would make someone inadmissible? Well, here you'll see a list of the most common inadmissibility grounds that we see. And these involve prior immigration violations, such as entry without inspection or a prior removal order. It also includes things like false claims to US citizenship or fraud or misrepresentation or smuggling. So a lot of our clients brought their children with them when they came to the United States illegally, and many people don't consider that smuggling, but technically under the law it is. And so we would ask that that ground of inadmissibility be waived so that the client can be eligible for a U-Visa and eventually be eligible for the green card. So as I mentioned, the waiver is found on Form I-192. And in order to qualify for the I-192 waiver, you have to prove that it's in the national or public interest for the client's waiver to be granted. It is discretionary. But what does that mean, national or public interest? Well, it's pretty vague, but these are the things that USCIS will consider, okay? They're gonna look at evidence of rehabilitation. So if your inadmissibility ground, for example, is a criminal violation, is it something that the client did repeatedly, continues to do? Well, that's gonna be harder to show rehabilitation. But if they had one incident 20 years ago, then, and they can show that they have rehabilitated, that will be helpful for their waiver. Reasons for wishing to remain here in the US, any mitigating factors, you know, for example, family ties here in the US, community service that they've done, involvement in the community. Affidavits of the applicant are essential in explaining all of the circumstances surrounding their inadmissibility grounds. You would want to talk about any loss of access to the US criminal justice system and access to any social services or healthcare that the client has here but would not be available in their home country. Okay, now the U-Visa application is on Form I-918, and there is no fee for the U-Visa application. However, if your client needs an inadmissibility waiver and they're filing Form I-192, there is a fee. You'll see there it's currently $930. That's quite expensive for most of our clients. So fortunately, there's a fee waiver available. Okay, Liz is going to go into that a little bit later. One of the things that I want to mention here that is relevant to our U-Visa clients are these confidentiality provisions, okay? So especially survivors of domestic violence are often afraid to go forward with any sort of immigration relief because of fear that the perpetrator will find out. And so, you know, we will address this with the client as it comes up, but if it comes up with you, their pro bono attorney, we want you to be able to inform them that there are actually provisions within the law that prevent immigration officers from disclosing this information to third parties, okay? And that's important. We tell our clients that we don't recommend that they tell the abuser that they're applying for a U-Visa, because oftentimes that kind of information can backfire and the abuser will try to use it against them. You know, you'll learn more about that in a moment when Liz talks to you about the manipulation that abusers use. But if someone is applying for a U-Visa, the Department of Homeland Security and Department of Justice employees are prohibited from providing any information about a U-Visa applicant to a third party, such as the perpetrator, okay? And they're similarly prohibited from making any decisions about the removability of someone based solely on information provided by the abuser. So you might wonder, well, how would that even come into play? Well, unfortunately, we've come across a number of cases where the abusers have threatened to notify immigration and have actually made attempts to notify immigration, and they'll say things like, you know, so-and-so is making all of this up just to get a U-Visa, none of it is true. So fortunately, the officers that adjudicate these cases are trained in domestic violence and understand that that is often a tactic that abusers use to manipulate and control the victim. But it is important to know that there are protections under the law for the clients. Okay, so we have got a case example here. And so I'm gonna go ahead and read the example. And if you want to provide any comments or questions, go ahead and do so in the chat. Ana is a Mexican citizen who entered the US without inspection in 2010 with her 1-year-old child. In 2012, 2 years later, she married Juan, who is undocumented, and they later had 2 US citizen children. During the marriage, Juan did not allow her to leave the house without his permission. He controlled all the money and often threatened to have her deported. On one occasion, he repeatedly hit her and she called the police. Juan fled before the police arrived, but Ana filed a police report. Juan was never arrested. Okay, therefore, after that, she took her children to a domestic violence shelter and obtained a civil order of protection. She is now seeking a divorce, but he continues to call her and threaten her. So, who thinks that Ana might be able to apply for a U-Visa? This is where it'd be nice if we were all on Zoom and people could raise their hands or shake their heads. Obviously, I can't see any of you, but I've got a couple of hands raising. A couple of people have chatted to me. Yes, Ana can definitely apply for a U-Visa, right? She's clearly been a victim of domestic violence, so she's a victim of a qualifying crime. She's going to have to prove that she has been a victim of qualifying crime and that she has suffered substantial harm. So things like records from the domestic violence shelter, the order of protection, possibly even her divorce, right? If she can get language in the divorce that talks about being a victim of domestic violence, she can reach out to anybody who she may have told about the abuse for letters of support. So all of that can go towards proving that she's been a victim of a qualifying crime and she's suffered substantial harm. The fact that she reported this to the police is enough for her to show that she cooperated with law enforcement, as long as she can get the certification signed by the law enforcement agency. Now, because Juan was never arrested and there was no prosecution, she probably can't get a certification signed by like a state's attorney's office, but that's okay. There doesn't need to be prosecution as long as there was an investigation and she cooperated with that investigation. So she very clearly, to me, is eligible for a U-Visa. Does Ana have any inadmissibility grounds that she would need to have waived? Yes, yeah. So she entered the United States without inspection. So she would need to ask for a waiver for her EWI entry without inspection, and for smuggling her child, right? So she brought her child with her. He was born in 2009. So let's see, in 2009, he still will qualify as a derivative. So he can be included as a derivative on the application. We would do a separate intake for her child, make sure that he is eligible also as a derivative. So this is a very typical case that could be referred to one of you through our pro bono project. So that is the end of my part of the presentation. I'm going to go ahead and turn it over to Liz, who's going to talk to you all about working with survivors of domestic violence. Take it away, Liz.
Thanks, Trisha. There's actually a question, but I think we can definitely answer this later on. What immigration status does the person have while the U visa application is pending? And can the person travel once the visa is approved? And so, like I said, we can talk more about this, but essentially, whoever, when someone is applying for the U visa, they submitted their application, it's a really long wait time. And so there is no immigration status during all those years until they are placed on the wait list. And that's when they are granted deferred action. And can the person travel once the visa is approved? No. We can talk more about this later on, but essentially the answer is no. But thank you for your question. So Tricia, if we can just move on to the next slide. Thank you. So as Tricia mentioned, people seeking protection under the U visa have been victims of violent crimes. And some of these qualifying crimes vary. However, most of the U visa cases that we see in our office deal with gender-based violence, such as domestic violence and sexual assault, which is why we will be focusing on these, specifically in this case, domestic violence. And so this means that there's a significant amount of trauma. We'll go over some best practices and information that would be useful to keep in mind when working with clients who have survived these crimes. And if we're discussing domestic violence, we should first define it. So domestic violence is a pattern of physical and psychological abuse used by one person to exert power and control over another in the context of dating, family or household relationship. And throughout this presentation, I will mostly be referencing to relationship abuse because this is what we often see. There's also this huge misconception that we should get out of that domestic violence happens more often in immigrant communities. And so domestic violence is an issue that exists amongst all races, genders, sexual orientation, socioeconomic status, etc. Men can face domestic abuse, and abuse can also exist in non-heterosexual relationships. And so it's all about underreporting, and there's many reasons why people experiencing abuse might not speak out and seek help. And so let's talk about the tactics used by abusers in situations of domestic violence by looking at this power and control wheel that you have in front of you. So both sexual assault and domestic violence are about power and control. If there's anything that you take away from this section of the presentation, it's this. We know that an abuser asserts their power and control over their partner in physical and non-physical forms of abuse. And we really like to reference this wheel of power and control so that we have a visual of the overall pattern of abuse and violence that an abuser uses to maintain control over someone, and how some of these methods are very specific to the immigrant population. Some of these ways that an abuser may exert power and control over someone is through economic means, intimidation, and isolation. We've heard many times how survivors of domestic violence felt trapped in their relationship because their spouse or their partner controlled all the money. A large number of abusive partners also bring violence into the workplace. They could be stalking their partner, checking their emails or phone, threatening them or their workmates. So some of this is about trying to break their partner's attachment to their job and maybe get them fired or get them to quit so that they are more dependent on their partner. And we often hear about how the survivor had to endure not being able to see their family or friends because their partner would not allow it, or their partner would get very jealous. So a red flag would be this: when a partner tells their significant other, your friends aren't allowed to be with you unless I'm there, or you can't go see your friends or family. And this is important because when an abuser isolates someone from their friends and family, they're not only trying to make it easier for them to be manipulative, but it also creates this dependency on the abuser for support. And so other acts of abuse that you see here are emotional and verbal abuse, which can be seen as insults or humiliating them at home or in public. The abuser might threaten to commit suicide. They might threaten to take the children away or hurt them. They might also threaten to act against animals if they have pets in the home or objects. And so in a lot of these cases, there will be no physical violence, and instead abusers might use other tactics that won't leave a trace on someone's body. And so I think that these forms of violence are actually done more often, because if the survivor were to speak out, no one might believe them. Let's say they call the police and the police comes over after a domestic violence incident, but there's no marks on their body, no blood, nothing to really show, right, to the visible eye, like that anything happened, but we don't know behind closed doors all that person has been suffering. And so this is done very intentionally so that survivors won't be able to do anything about it. We can go on to the next slide. And so here we have the cycle of abuse. We also like to use this because when we work with survivors of domestic violence, there is a cycle of abuse that often happens. We might ask a survivor of domestic violence how their relationship was in the beginning, because this often tells us a lot about how it starts off as a honeymoon phase, where the relationship starts off with a lot of love, a lot of kindness, and people will describe that, especially when you're working with someone on their affidavit. This phase might not last very long, but then we often see this moving into this tension building phase where there might not be physical violence yet, or not at all ever, but the abuser may start to slowly isolate their partner, start controlling the money, small things that are red flags to isolate the individual. And we give some examples here of other red flags that might occur during the tension building phase. And then after this tension building, it can lead to an explosion where there could be physical violence. It's not always the case, but this is what we typically see, especially when working with U visas. We see that this is when someone might call the police. And so after an explosion, the abuser might try to patch things up by asking for forgiveness, by blaming their partner for what happened, and maybe try to be romantic. And this might work because the one experiencing the abuse believes them. The violence is then repeated through this cycle. And what ends up happening is that this honeymoon phase disappears over time, and there might be a lot of denial and self-blame from the victim. And it's not in every case that there's this continuous victimization over many years, but we do see this often in the cases that we work with. And some of our clients have been able to leave their abuser, and they might live in a domestic violence shelter or with family or friends. Others may continue to live with their abusers throughout the process of applying for their U visa, particularly where there are children involved. And so it's important to keep in mind that everyone's situation will be different, but it's helpful to know this to be able to provide the support that your client might need. throughout the process of applying for a U visa. And people may wonder, right, why someone wouldn't just leave an abusive relationship. And so leaving is actually one of the most dangerous times for someone who has been abused, because when a victim decides to leave, they are basically taking control and threatening the abuser's power, which could cause the abuser to retaliate in very destructive ways. And so leaving could sometimes mean death to the victim. So it's important to refrain from giving your opinion to someone who is experiencing domestic violence, especially if they're still living with their abuser, because who better knows their abuser other than the person living with them, right, and experiencing the abuse. All you can do is provide the resources, provide the support, and help them through this process in the hopes of one day getting their independence and taking back their control, and possibly referring them to counseling if they haven't already gone to counseling, things like that. So here we include some of the cultural barriers that our NIJC's clients face. So there's a wide range of different cultural, religious, and socioeconomic backgrounds from our clients, and they might face many challenges with respect to their immigration status, but also other barriers that we often don't talk about in regards to trying to access legal counsel for immigration relief, and in this case, break the cycle of abuse. Some of these barriers can include, but are not limited to, language limitations, feelings of extreme isolation, right? Feeling like they're alone and that no one might understand. Maybe they're alone here, they don't have family that they can call or go to in case they need support. There's also cultural ideas of family shame and honor that can stem from someone's home country and trying to adapt to the new culture and systems here in the United States. And this can also be linked to how domestic violence or relationship abuse is a topic that is also oftentimes taboo. There's also close-knit communities, which can be a great asset to a lot of people, but also can sometimes make it difficult to seek help if experiencing domestic violence. For example, there may be a belief that the close-knit nature of the family prevents domestic violence from occurring, or that the family is the only appropriate forum for dealing with issues like that. And so in some instances, outside interference is not encouraged or accepted. And so it's important to note that there's a general mistrust too with law enforcement agencies, medical and criminal justice systems, especially in immigrant communities, because they've been failed by these systems. And there's also the role of religion that can be a barrier, but also can be an asset in many ways. And so, as we said, domestic violence is not unique to a particular community, race, or culture. And so while cultural differences must be considered, it's important that assumptions should never be made about someone's culture. And we can move on to the next slide. And another method of control and power that comes up very often, especially in cases of domestic violence, is when the abuser uses the survivor's fear related to their immigration status. An example of this is when the abuser threatens to contact immigration authorities to notify them of their spouse's undocumented status. We've heard many times when this happens, when an abuser who is a US citizen, for example, has gotten in contact with immigration, and they tell them that their spouse is a fraud and only got married to them because they wanted to get a green card. We've also seen situations where the abuser might file a family-based petition for their partner and then later withdraws it or uses it for manipulation and control. So these are just some examples. You can go back to this presentation to use as a reference when you're working on the case. But for now, we will be taking a quick break. But before that, I'm not sure if there's any questions, Trisha.
No, actually, I'm going to go through during our break and I'll respond. I think you touched on the only question that we've gotten so far, but I forgot to ask that last poll question So since we are a little bit ahead of time, Liz, why don't you go ahead and send out that last poll? We'll see if people were paying attention.
Okay, let's see. All right. So in order to qualify for a U visa, does the criminal case have to end in prosecution of the perpetrator? No, yes, or unsure? Okay, just a few more seconds before we close the poll. All right, so 100% of people said no. That is correct.
Yay. That's great. That means you're all listening and learning something. Wonderful. Okay. Well, feel free to send us any questions that you have. I know it's been a lot of information so far. We are about 10 minutes ahead of schedule, but we're going to go ahead and take our break right now. We're going to still keep it to a 10-minute break so that we can use that extra time at the end for questions or maybe get done early. But yeah, so it is 5 minutes to 12 here in Chicago. Let's come back at 5 minutes after 12 and we'll see you all then. Okay, we'll give folks another minute to rejoin us. So I want to thank everybody who has submitted questions. I went ahead and replied to the questions that we already had, but feel free to keep those questions coming. Just a quick summary. So Liz already mentioned the question about whether somebody has status while their U visa application is pending. No, no, they don't, unless they already had status through another means, like a student visa, for example. And then once their U visa application is approved, do they have authorization to travel? No. So if you file an I-918 application here in the United States and it's approved, you're granted U status. You're not given a U visa to travel, okay? That is a distinction because somebody that is applying for an I-918 abroad, when their case is approved, they will be given an actual visa in their passport that allows them to enter the United States. It's a multiple entry visa, sorry. If somebody is granted a U visa here in the United States, U status, sorry, and they leave, they are most likely going to trigger another ground of inadmissibility, the unlawful presence ground. And when they do that, they would need to file a new I-192 waiver, then they would need to consular process, and they would need to return to the United States within 90 days, or they put their future adjustment of status application at risk. Okay, all of that is more complicated than any of you need to know for filing the U visa application. But for those of you that are familiar with this process and want to know what if, I hope that's helpful. Okay, if you have further questions about that, just message me separately. Another person had a really good question about confidentiality. So if somebody has a friend or family member in the room with them for support, does that destroy client confidentiality? And how would you deal with that? That's a great question, and it could come up. And so I would encourage you to then explain client confidentiality to your client, and that you are bound by client confidentiality, and you will, of course, maintain that, but you can't make any guarantees for anybody else in the room with them, right? And so hopefully you can develop a relationship with your client so that they will at some point feel comfortable speaking to you, just you, without somebody else there. For some people that never happens, whether it be because of trauma, you know, maybe they feel most comfortable with their caseworker in the room. In those situations, they probably also have confidentiality with their caseworker. But if it's like a friend or family member, right, it's important that the client understand that that is up to them if they want to divulge this information to somebody else, okay? So, you know, if you need tips on how to have those conversations with your clients, please reach out to us. And then somebody asked, what time does the webinar end? It does end at 1 o'clock Central, so about 50 minutes from now. So we're gonna keep rolling along. Take it away, Liz.
Thank you. Thanks, Trisha. Okay. So if we can just move the slides. Awesome. Okay, so practical tips for preparing a U visa case. This is where we go into the nitty-gritty of what a U visa application looks like, what you'll need. And so there's going to be a lot of information on these slides. So I won't be spending too much time on them. It's supposed to be used as a reference. So please feel free to use this for your future casework. We'll be sending out the PDF version of this whole presentation to you so that you can use it. And so first off, connecting with clients. From the beginning, it's important to create a space where your client feels safe. And so this might look a little bit different now that we're working remotely. On our website, we have some great resources for best practices for attorneys working remotely with clients during the pandemic. And I've already linked this resource in the chat box, so feel free to check it out. Also, check out all the other amazing resources we have on our website because we have so many, and we work super hard on, you know, getting all of these things up and, just having enough resources for you all to be able to be successful in your cases and with your clients. And so during the first meeting, it would be a good idea to explain your relationship with NIJC. Although we do explain this when we sign our pro bono retainers, it's still important to reiterate this because the client has already received so much information by this point. And so we want to make sure that everyone is on the same page. And it's always good to keep in mind too that speaking simply on a one-to-one level instead of talking in legal terms is a good way to communicate with your client. So don't use big words. Try to explain things rather than, state like a sort of like legalese term. If you need an interpreter, having one secured before you meet with your client for the first time will be essential in preparing the case and also for building a safe space for your client. Additionally, setting up a good communication plan is crucial, especially for individuals in situations that are still living with their abuser or they're not in a secure location like shelters or someone else's home. So ask them, what is your preferred method of communication? Can I leave a voicemail when I call and you don't answer? Can I send you a text message? What would you prefer? We always make sure to flag if someone's home address is not safe, but a client might move around or circumstances may change, and maybe their abuser steals their mail or their cell phones are constantly being monitored. So it's always just good practice to ask those things at the beginning. Stressing confidentiality is also extremely important when trying to build that rapport with your client. Explain that you will not be sharing information with anyone else unless they specifically grant permission to do so. For example, if you need to speak to their counselor, their therapist, right, with a signed release of information, of course. A lot of people can also have anxiety about their abuser or their family finding out about the case. Therefore, stressing that this is a safe and confidential space and creating that space for them will be beneficial. Something that might come up is that a client might ask you questions that are beyond the scope of the case. For example, they might ask about counseling, tax assistance, or other services. And so we don't expect you all to answer any questions beyond the scope of the case. And what you can do is just reach out to Trisha and I. We have many great referral options that we'd be happy to provide the client with or share with you so that you can then share with your client. And overall, explaining the process for a U visa is important in building that relationship of trust so that the client understands how long it can take to get a U visa, what are the different fees or waivers, or what documents they need to bring you. During our own screening process, we get the certification form, as Trisha mentioned, and we put together a referral packet with all the documents that the client has already obtained to start their case. But it's always good to take time to review everything closely with the client to see if there's any more evidence that can be included or excluded to strengthen their case. And we have a sample list of documents in our manual appendices and other resources on our website that are readily available to you. And I've also attached actually some of these resources to today's presentation as handouts, so check those out. Okay, next. Client meetings. So I've already touched on this a little bit, but and Trisha as well, it's important to just make sure that you have all the original documentation that you need. In this case, it's the U visa certification. So it's best to make sure that you have this during your initial client meeting. And we recommend you get to know your client's story as well. This is part of building that relationship of trust with the client. But this is going to take time, obviously. So what we recommend is that in that first few meetings, you begin filling out the application forms, give the client a list of additional documents they need to bring, and then schedule your next meeting. Again, during this first meeting, explain the process, explain the fees, the waivers, anything additional that they might need. In subsequent meetings, that's when you can start really getting more in depth on the affidavit. And so in the affidavit, it's going to be a case-by-case basis how this is going to look. You should gauge your client's comfort level. You might have someone who was a victim of felonious assault, where the incident might have happened several years ago, and they've maybe gone to counseling, they've moved through it, and maybe they're ready to work on their affidavit and talk about the substantial harm that they suffered. But that's not always the case for everyone. I think especially in cases of domestic violence. So it's good to be aware that not every person will be ready to share their life story with you right away. And the difficulty in telling one story is also compounded when having to use an interpreter. So keep that in mind. Some people might immediately open up to you, and others might be a little bit reluctant to talk at first, and that's okay. And so what we like to do in our referral packets is share with you our internal case notes from our legal screening so that you have a basic understanding of who this person is, who their family members are, and what they've gone through in relation to their case. And so you definitely should confirm all that information as well and take a look at it before meeting with your client. And if working on a case with domestic violence, everything that we talked about before when looking at the power and control wheel can be extremely helpful to use when sitting down, well, not sitting down in this case, but talking to your client, right, about what they've experienced. We recommend you use this as a tool to maybe help the client identify some of these forms of abuse that the client might not have maybe thought about before. And when your client does open up to you about traumatic events in their life and the details regarding that crime that they suffered, you should actively listen. Be non-judgmental, be empathetic, and validate their decision to disclose the difficulty of being vulnerable in that situation. You can say things like, thank you for having the courage to share that. Your feelings are completely valid. I get why you feel that way. Things like that. If someone is still living in an abusive situation, it might help to also ask, what do you need right now? Is there anything I can do to support you? Never ask questions that begin with why, or ask leading questions, which leads the client then to answer the way that you want them to. We should try to avoid that, especially when working on the affidavit. It is appropriate to ask open-ended questions. For example, how and what questions. How did you feel when they said that to you, for example? Okay, next. So as for evidence, each principal and derivative applicant must have their own complete application packet, including cover letter, forms, identity documents, supporting documents, and affidavit. And what should an affidavit look like? So to start, the affidavit should be in the applicant's own words, because this is their chance to tell their story. What this can mean is that the client can write their affidavit in their native language and then have a certified translation of it. However, what we have found is that the best affidavits are the ones where you talk with the client one-on-one and draft it together. Because it might be difficult for the client to know where to start, what exactly you're looking for. So we always find it very helpful to just do this with the client. The client's original signature also needs to be on the affidavit, and if there was an interpreter used, their signature is also needed to show that they provided an accurate and truthful interpretation. The affidavit essentially addresses, so there's a few things. The affidavit is important because it has basic biographic information, substantial physical or mental abuse, knowledge and information about the crime, how they were helpful in the investigation or prosecution of the crime, and reasons why their granting of the U visa is in the national or public interest. This is where someone can go in depth about these things, which are the requirements for a U visa. And so for principal applicants, we can move on actually, yeah. So filing procedures here, for principal applicants, you see that we need a cover letter, index, forms, supporting documentation. That's their own packet. Derivatives, they have their own packet that looks very similar, but they wouldn't need to prove all of the other requirements that the principal would need to prove, as Tricia had explained earlier. Here, we see the details of what a principal's application packet would look like. Like I said, the cover letter, the index of documents, and the following forms. They will need the G28, the waiver of inadmissibility if they need one, the original U visa certification form. If they're applying for their work permit right now, they would need 2 passport style photos and the fees associated with those forms. We list here some of the supporting documents that you should include, but you should refer to the U visa manual and appendices for more details. Okay, next. And for the derivatives application packet, you see here that they'll need a lot of the similar forms like the G28, but instead of the I-918, it'll be the I-918 Supplement A. And if they need a waiver, they'll include that. And if they'll be applying for the fee waiver request, they would need to file Form I-912 with supporting documentation. And if they are applying for that fee waiver request, that would cover the waiver of inadmissibility and the I-765, because those are the forms that have the fees. And you see here that we include some supporting documents that you should be including in the derivatives application packet. Note that you will need to prove the qualifying relationship of the derivative to the principal applicant. This can be a birth certificate for children or a marriage certificate for a spouse. Okay, so in terms of employment authorization, this might be something that clients might ask a lot about, because this is essentially why they are applying for the U visa. This is super important. It's life-changing. So USCIS will automatically issue an initial work authorization in category A19 when they grant the U visa for the principal applicant who is living in the United States. That is valid for 4 years. For derivatives, they will not get an automatic work permit when their U visa is granted. So you will need to file the Form I-765 in order to receive that work permit that is valid for 4 years, but it will be in a different category. So it'll be A20. As you can see, there are various categories for employment authorization, and it can be a little confusing, a little tricky. So we've included it here for you. Now, due to the cap of 10,000 U visas per fiscal year, USCIS will issue a waitlist notice and grant of deferred action for applicants in the United States, which then allows them to apply for a work permit while they wait for a U visa to become available to them. Therefore, we recommend that if you're initially filing a fee waiver request for the waiver of inadmissibility, you should also include the Form I-765 to apply for a Category C14 work authorization when filing for both principal and derivatives, so that by the time they get deferred action in 5 years or so, they will automatically get their work permit, that's C14, and the grant of deferred action. So this C14 work authorization is renewable every 2 years until they're granted their U visa. If you don't file the C14 work authorization initially with the U visa application, you can always file it once the client receives the waitlist letter, once they've been put in deferred action. So remember that being placed in deferred action is taking years right now, and this can change at any time. So it's important to just set these expectations continuously with your client, as you might have explained this in the beginning. We might have explained this as well, but it's just a really confusing process and it's a long wait. So you might have to be continuously, explaining this over and over again. All right, so we've included the filing fees for each form here that you'll need. As you can see, the U visa form, the I-918 for the principal and the I-918A for the derivative have no cost. Meanwhile, the waiver of inadmissibility, which is form I-192, has a cost of $930, and the work authorization has a fee of $410. So all fees should be in the form of a money order and payable to the Department of Homeland Security. You can file a fee waiver request for both of these forms, as I mentioned previously, if the client can provide sufficient supporting documents to prove that they qualify for this fee waiver. So to request the fee waiver, right, you need that form, the I-912, and also we list here some of the things that clients can use to substantiate that they qualify for this fee waiver. So some things to note are they receiving a means tested benefit? They could apply based off of this. If they have a household income of 150% or below of the poverty guidelines, or if they can demonstrate financial hardship. So they can choose more than one of these requirements for the waiver, and they should try to gather as much as they can, because the more the better. We've seen that it's become increasingly difficult to receive a fee waiver with a Vermont Service Center. So if the fee waiver gets rejected or denied in this case, then the waiver of inadmissibility and the work authorization gets rejected or sent back. And then what you'd have to do is either refile this with more evidence, or the client can decide to pay the fees with the money order. Okay, next.
Liz, I'm just going to jump in real quick because we have a question that's kind of relevant to what you're talking about right now. Somebody asked, given the long wait times, even for deferred action, how do we advise clients about their ability to support themselves or their family while they're waiting for work authorization? And is there any other way to obtain work authorization? So I do want to say that at one point, it only took about 6 months to get placed on the U visa wait list. That was years ago. USCIS has significantly slowed down their processing time since then. I'm hopeful that one day they will speed things up again. Maybe we'll see improvements under the new administration. Obviously, we can't make any guarantees of that. And so, as Liz mentioned, it's really important that you are upfront with the client and explaining these processing times as they are right now, because inevitably we hear from people, yeah, but my neighbor or my friend or my relative applied for a U visa and they got their work permit in a year. What are you doing wrong? Why am I not getting my work permit, right? So it's important that they understand these waits from the get-go, so that they understand it's not your fault, it's not our fault, it's USCIS adjudication times. But to answer your question, what can they do? Some people will qualify for work authorization based on other applications that they might have pending with USCIS, okay? If that's your client's case, that's great. That is not the majority of our U visa clients. Most U visa clients that we see in our office do not qualify for work authorization until their case is placed on the wait list. And so, we can't encourage clients to break the law, but the reality is most of our clients are working without authorization, and that is just a fact of life, okay? How does that affect their case? It doesn't necessarily affect their case, because working without authorization is not an admissibility ground that needs to be waived on their U visa application. However, if they are making a false claim to US citizenship, then that is an inadmissibility ground that would need to be waived. If they are committing identity theft, that is obviously more serious, and we would advise clients not to do that and encourage them to immediately stop that. So, we usually see those on intake, and so we'll advise the clients as those things come up, but in the event that you see them, please reach out to us, okay? So there's a couple other questions about fee waivers. I'm gonna go ahead and answer those privately. I just wanted to jump in because I figured that was something that probably a lot of people are wondering about. So thanks, go ahead, Liz.
Definitely, thank you. Yeah, so as we continue here, filing tips. So here we give some tips on, how to file this application, right? It's always Important to include certified English translations for any foreign document that you submit. In our manual appendices, we have provided a certificate of translation template for you to reference. Also, all USCIS forms, you should confirm before submitting that you are using the most recent version of them, because USCIS does update their forms pretty regularly. And so you can just check out their website just to make sure that you're using the right edition. And it's also very, very, very important that you answer all the questions on the form I-918 and I-918A if you're including a derivative petition. This means that if any question is left blank, even if it does not apply to the client, the application could get rejected. You will need to put not applicable or none or N/A if a question does not apply. And so you can do this directly on the form as you're typing. I believe now you're able to do that. And so sometimes what I like to do personally is just handwrite it down just to make sure that I miss no question. And so we've seen many applications get rejected lately for this reason, which is very unfair. And that just means that, we'll have to be even more careful. So NIJC and others are advocating on a policy level to change these really harmful practices. And we hope that this does not continue. But for the meantime, we do have to be very careful with this. Some logistical tips. Application packets should be 2-hole punched at the top and binded with metal prong fasteners or a binder clip. Do not use spiral binding. Don't use tabs or other exhibit markers. Use page numbers or stickers instead on the pages. The reason for this is because the Vermont Service Center needs to scan the whole application packet once it's received. And so they can't do that if there's tabs sticking out or the spiral binding. They'll have to cut it off or try to work it out to scan it essentially. You'll need to prepare separate application packets for the principal and derivatives, like we mentioned previously. And when you're ready to file the application, you will place all the application packets into one mailing envelope and send it through Federal Express or another trackable delivery service. And we always recommend to keep a digital copy of the final application packet you send to USCIS to forward to us for our records and also for you to keep as well. And next, where to file. We've included here the address of where you should be mailing this application, which is the Vermont Service Center. Next. Okay, so here we have somewhat of a timeline of the U-Visa. After filing your U-Visa, the U-Visa packet, you should receive a receipt notice indicating that USCIS received the application. So this could take about 4 to 8 weeks. It might take a little longer right now due to COVID. And the form of this receipt is I-797. Then you should receive a biometrics appointment notice for your client. Everyone should attend their biometrics appointment or their application will be considered abandoned. Right now, USCIS is still scheduling biometrics appointment consistently, although it's taking a little bit longer to schedule them. The attorney does not need to be present for this appointment. It's a very quick process, but it's important to attend it again, because if they don't, then it will be considered abandoned. If they need to reschedule it, that can also be done as well. The client will need to bring their original biometrics appointment notice and a government issued photo ID when they go. For clients with derivatives outside of the United States, the client will receive a request for evidence with an FBI print card to send to the derivative abroad. Derivatives can get their fingerprints taken at a US embassy, and embassy officials will process the prints and send them to the Vermont Service Center for processing. So NIJC can guide you through this process if you have a case where the derivative is abroad. So after this biometrics appointment, it will be a very long wait time for USCIS to review the application and make a decision because of the statutory cap. So currently, USCIS is looking at visa applications filed around March of 2016. That kind of gives you an idea of how long this is taking, which is approximately 58 months just to get on that wait list right now. And so if USCIS issues a request for evidence, please contact NIJC immediately so that we can advise you and guide you through it. It's important to note that all immigration notices are only sent to the attorney. So this means that the client will not receive any notices, and that's why it's super important, especially with the long adjudication times, that you maintain the client communication. And the client should also do that with you as well, inform you if they changed addresses, if they changed phone numbers, so that you can keep that communication, but also let the Vermont Service Center know that if the client moves, they need to be notified in writing. So we do ask that you keep us updated on anything filed, on anything received, and also provide any notices received to your client. Next. All right, as mentioned, right, USCIS is currently looking at visa applications filed in March of 2016. And so when a visa application is reviewed by USCIS, if it is deemed approvable, but there is no visa immediately available due to the 10,000 annual cap, USCIS will place the case on the visa waitlist and grant the applicant deferred action. Deferred action is not a legal status. It's not an immigration status, but it does offer protection against being placed in removal proceedings. So it is very important to someone living in the US and trying to work, because at this stage, the principal and the derivative become eligible for a work permit based on that deferred action. Again, this would be category C14, and if it was submitted with the initial visa application, the work permit will be issued at the time that the case is placed on the wait list. And so we ask that pro bono attorneys agree to stay with the case until the client has been granted the final decision of non-immigrant status. However, we do understand that the visa application process is very lengthy, and so we also offer the option of transferring the case back to NIJC once it is placed on the visa waitlist and the client is granted deferred action. Okay. And keeping in touch with the client, I've already touched on this, but I can't stress it enough. Especially with these long wait times, it can be very stressful. It can be such a long time and a huge burden on someone who is just waiting on their work permit, on any kind of benefit from this. And so you might get calls from your client, you might get emails. And so it's important to keep that communication and maybe re-explain the process once again, just as a reminder that, how long this is taking. And you can look at the processing times online on the USCIS website to give kind of an idea of, what USCIS is looking at right now in terms of visa cases. But it's just super important to keep that communication. Also, if your law firm moves or you change address, you must notify us, NIJC, and the Vermont Service Center. Okay, next. And the visa approval. You should receive approval notices of all forms, but keep in mind that they may arrive separately. So please notify NIJC when you receive any notices in the case. Keep us updated, keep the client updated. If a client has questions about traveling, or if a derivative is outside of the US, once the visa has been approved, you can refer those questions to us. And so essentially, after 3 years of having non-immigrant status, clients may be eligible to apply for their green card or adjust status. And so if a client contacts you about this, please refer them back to NIJC for a legal screening. It's important that they apply for adjustment before their U visa expires, or they might lose their eligibility to apply. They can also lose eligibility if they travel outside of the US while they're in non-immigrant status. Okay, so here we've included some of the legal references we use throughout this presentation in the PowerPoint, as well as referrals that can be useful for your client. Just email us if you need any extra resources, especially for clients looking to apply for public aid or look for any counseling. Feel free to use this PowerPoint again as a reference for your future casework. And thank you all for hearing us out throughout these 2 hours. I hope this training has been helpful. And after this training, you should be receiving NIJC's email newsletter. So Tricia, if you can go to the QR code, possibly. I think it's the next one. There you go. So please, if you can just fill out our survey very quickly. It's a very short survey, very helpful for our pro bono programs. We've also listed in the previous slides our contact information for Tricia and I if you're interested in working on a U visa or a VAWA case, if you've already attended a VAWA training, or if you want to, we have one coming up next month. And yeah, you will also be receiving Illinois CLE credit if you gave us your AARDC number when you registered. If you did not get to provide that initially when you registered, you can also email me after the presentation. So thank you, everyone. I think we can go to questions.
Yeah, so we have received some great questions. I really appreciate everybody who submitted questions. If you have more questions later, don't hesitate to reach out. So some of you, I've already responded, but I thought they'd be helpful for the group to hear. So, one person asked for some clarification on deferred action, and what does that actually mean? So it's a little convoluted, but essentially USCIS created the wait list in response to the large backlog of U visas, right? So because there is a cap of 10,000 visas per year, that the backlog has grown. I would say, about 9 or 10 years ago, they weren't granting 10,000 U visas because there weren't that many applicants. But as time went on and more people became aware and more people applied for the U visa, they started to reach that cap of 10,000. And so as they reached the cap, then people that were approvable, but there's no visa available, had to be put on the wait list. Okay, and so the wait list grew and grew, and so did the backlog. So cases are adjudicated in the order that they are received. So when USCIS gets to your client's case and reviews it, if everything looks good and their case is otherwise approvable, except for the fact that there's not currently a visa available, then their case will be placed on this U visa wait list and they'll be granted deferred action. Okay, so deferred action is not an official status, but it does provide protection from deportation or removal. And more importantly, for most of our clients, it provides a means to apply for work authorization, right? So once they're given deferred action, once they're placed on the e-visa wait list and given deferred action is when they can get their first work permit. And to most of our clients, that is severely significant, right? So that is what all of that is about. It's not a status, but it will allow them to have a work authorization until the U visa is available to them and they're given their actual U visa. Okay. Somebody else asked, should you give a copy of the entire packet to the client? That is definitely good practice, right? It's not required, but we definitely encourage it. And I would encourage you to discuss with the client what the best way for them to receive a copy of their file is. Some people might want a physical copy on paper, but some people might prefer an electronic copy, right? So keep in mind that all of the correspondence is going directly to you, the attorney of record. And so we really encourage you to give a copy to your client of anything that you file, but also anything that you receive, any correspondence from USCIS regarding their case. Okay, now somebody else asked a really great question about fear. in applying for U visas. And we actually used to have a slide about ICE enforcement, and I took it out because thankfully we are not seeing as much ICE enforcement in our communities these days, and that's a good thing. But that doesn't mean that fear is gone, right? A lot of people still live with fear every day because they are undocumented, and fear of applying for an immigration relief is real for a lot of our clients. We usually have an opportunity to discuss this with clients on intake. So chances are by the time the client gets to you, they have already determined whether or not they want to proceed. But obviously things can happen throughout the life of their case that they may change their mind. Most of the clients, I think, although they might have some fear, really also want to resolve their immigration status. And if this is a way to do that, most of them will choose to take that risk forward. The other thing that is in their favor is that there was an NTA memo, notice to appear memo, that came out during the Trump administration indicating that any denied applications would be placed in removal proceedings and issued a notice to appear, which is how somebody ends up in immigration court. So we have, over the past few years, seen some U visa cases denied and placed in removal proceedings, but most of the cases that we file in our office are approved because we believe that they are approvable, and we wouldn't be filing for somebody unless we thought that their case was approvable. There are some clients who are at greater risk of being denied because of, for example, lengthy criminal records or complicated immigration histories. We discuss that with the clients at the front end, and we explain that to the clients up front so that they can make an educated decision about their case because it's their lives at stake, right? So we understand this fear, and we make sure that the clients are making an educated decision. That NTA memo, the Biden administration has stopped it. I know that there are some litigation challenges to some of President Biden's recent executive orders and policy changes, but as of right now, we are hopeful that denied cases will not automatically be referred to immigration proceedings in court and not automatically issued an NTA. All of that to say, if cases are pending for 5 years, right, we don't know who's going to be president or what the administration is going to look like or what adjudications will look like in 5 years. And so it's really important that clients are making educated decisions, that they understand that there is a risk. We can't make any guarantees. I can see a case and believe that it is the strongest case possible. I still can't guarantee that it will be approved. All I can do is explain to them that based on the information that I have thus far, you know, years of doing this, and we are in touch with people nationwide who are doing these kinds of cases, this is what I anticipate will happen in your case, and then they make the decision. Okay, that's a very long explanation to your question, but I hope that that is helpful. I think, let's see. Okay, so for the QR code, there is, if you're having challenges with the QR code, there's also a link to the survey. Liz, do you want to go ahead and put that in the chat, just so people have it in case others are having challenges? And yes, we will share the slides. In order to get the CLE credit, you must complete the survey, and we do look forward to hearing your feedback. If you are an attorney licensed in Illinois or Indiana and did not include your bar number at the time of registration, please email it to Ellen by Monday so that you can get your CLE credit. That's all the questions that I have here. What time is it? We've got 10 minutes. Liz, do you want to go into any of our case samples? I think you're muted, or I'm just not hearing you.
Yes. Sorry about that. Yes, definitely.
Okay. Liz, I know you've been talking for a while, so I'll go ahead and read this, give you a break, and then we'll jump into people's thoughts. So Maria is a citizen of El Salvador and entered the United States by crossing the border with a group of people she did not know through Mexico in 2010. The first time she tried to enter, she was stopped by immigration and returned to El Salvador. She then entered successfully a few weeks later and had no contact with immigration. Subsequently, she met a man at work who was also undocumented, and they got married in 2013. They had 2 US citizen children together. And after their daughter was born, her husband became jealous and began to drink heavily. In one incident, her husband was intoxicated and he began smashing their dishes in anger. He threw plates and cups at Maria and she was injured. She called the police for help and gave them a report of the incident, and her husband was arrested. She got an order of protection against him, but does not know if he was ever prosecuted for the incident. So I'd love to hear people's thoughts. You can go ahead and put any comments you have in the chat. What do people think? Do you think that Maria has a U visa case here? Yeah, we're getting some positive responses. I would agree. Liz, you want to talk at all about what your thoughts are on this case?
Yeah, so I actually can't see the chat right now, but yes, likely domestic violence here. Even though this could also potentially be maybe felonious assault, but domestic violence, yeah.
Yeah, I agree. And she obviously will have some inadmissibility grounds that she'll need to have waived because she definitely entered entry without inspection, but she also had a border stop, right? So this is really common with a lot of our clients, and if necessary, we can file a FOIA, Freedom of Information Act request with CBP, Customs and Border Patrol, to try to get records of what happened when she was stopped by Border Patrol. But if you're running up on a deadline because her U visa certification is going to expire, or because there's an age out with a derivative, you can file this U visa application and request that a potential prior expedited removal order be waived, right? Just knowing what we know, in 2010, it was quite common for people to be stopped at the border and issued an expedited removal order if they were caught. And so it is possible that she has an expedited removal order on her record, and that would make her inadmissible, but it doesn't preclude her from applying for a U visa because she can ask to have that waived, okay? Now, the fact that her husband was undocumented does not affect her eligibility. It's actually not even, it doesn't even matter if they were married or not, except that that does make it very clearly domestic violence because they were living together. But as Liz said, that even if they weren't living together, this could potentially be a felonious assault case. And she would be able to prove cooperation because she reported the incident and she got an order of protection, regardless of whether or not there was prosecution. Let's see, it looks like we've got a couple of comments. Yeah, so people seem to agree. What do we got for time? Let's do one more case sample. Liz, do you want to read it?
Yeah. Okay, so Jane is a U.S. citizen. I'm sorry, Jane is a citizen of South Korea who entered the United States on a tourist visa in 2015. She told immigration that she was going to the United States on vacation, but she was planning to come to work and did not intend to return. Jane came to the United States with her husband, who was abusive and violent in South Korea as well as in the United States. Jane's husband frequently locked her in their house and threatened her. In one incident, Jane's husband severely beat her and she was taken to the hospital by her neighbor. At the hospital, Jane spoke to police and made a police report. From the hospital, she went to a domestic violence shelter. Her husband was taken to prison, and Jane testified in court several times. He is currently serving out his sentence. Okay. So, has Jane been the victim of a qualifying crime? Yes, domestic violence. Let's see, substantial mental, physical harm. What evidence would she be able to use? That's right, hospital records, her neighbor. Definitely her neighbor can, provide a letter of support. Yes, what else? Maybe a letter from the domestic violence shelter that she went to. And maybe if she attends therapy, that could also help substantiate that mental, physical harm that she suffered. And has Jane cooperated with law enforcement? Yes, she spoke to the police, right, and made a police report. That's right. And let's see, any potential derivatives? Doesn't look like it. And do you think that Jane requires a waiver of inadmissibility? Yes. Because even though she came in on a tourist visa, it was obtained by fraud, or she committed fraud when entering the United States. So that would be fraud or willful misrepresentation that would need to be waived for this. That's right.
So we have one more question here that I want to address. Somebody said that their client is having a difficult time getting police reports from the police department and asking where should you direct them. Well, unfortunately, this is a problem. I would say it's more commonly a problem if the case is ongoing, okay? And so, one place to start is you can file a FOIA request, Freedom of Information Act request, with the police department in question, and hopefully that will yield the results that you're looking for. If not, you don't necessarily have to have the police report, right? 99% visa cases we file do include a police report, but there may be other ways to prove that your client was the victim of this crime. And it's really the certification that is required. So want to try submitting a certification request to law enforcement or the prosecutor with any information that you know from the client. So usually when we request the I-918 Supplement B from law enforcement, we fill it out as best as we can and submit it to them so that they have a sample. Some law enforcement agencies will use the one that we send and add or delete or edit it accordingly, and some of them won't, and they'll simply discard it and fill it out themselves. Either way is fine. We like to give them positive language, right, so that there's no negative language on the certification for the client. So in a case like this, what we've done is we've filled out the 918B with the information from the client and sent it to the law enforcement agency or the prosecutor's office and asked them to certify. And then sometimes when they certify that I-918B, they'll send you records substantiating the certification. So maybe police reports or supplemental reports. So you never know what you'll get back. The other thing you could do is if you can't get the police report, you do get a certification signed, you could include any other documentation to prove the elements of the U visa. For example, do they have any hospital records or photos of bruises or whatever it is specific to their case. So that's it for the questions right now. 1 minute left. Thank you all so much for your time today. It's really been a pleasure, and we look forward to working with all of you. If you have any questions, please don't hesitate to reach out to us. Thank you.
Thanks, everyone.